Check 1, 2. Check 1, 2.
Okay, at this time, I would ask that everyone please find their seats.
Okay, we're gonna get started.
Hello, testing. Good. Perfect, thank you. Good evening. From the halls at McGeorge School of Law, my name is Josua Vasquez. It's my privilege and distinct honor to welcome you to tonight's program titled Pathways to the Bench. As former Chief Justice Tani Kantil-Sakaui eloquently stated, equal access means supporting a diverse judicial branch at all levels to benefit the public and to reflect the vast diversity of the state. And in the words of Judicial Appointment Secretary Luis Cespedes, the legitimacy of our judges and people's faith in our judicial system requires that our judges reflect that diversity. All of our panelists honor us with their presence here tonight, and I hope that their experiences, struggles, and victories may serve you well in your legal career. But by being here tonight, they are also speaking as one voice, that the California judiciary system is committed to ensuring that the leaders of tomorrow are equipped and encouraged to pursue a pathway towards the bench. And I hope that one day I will have the privilege to walk into your courtroom and say, Your Honor, may it please your court. With this in mind, please let's give a warm round of applause to Judicial Deputy Secretary Adam Hoffman, who will give us a quick overview of the judicial appointment process. Thank you.
Good evening, everyone, and thank you, Mr. Vasquez, for that nice introduction and for inviting me here to speak to you all today. As you heard, I'm the Deputy Judicial Appointment Secretary in the Office of Governor Gavin Newsom, and I'm very happy to come here and just talk you all through a process that may appear a little bit opaque from the outside, especially if you're in law school. But in my experience, even most lawyers don't really know how the system works. So it may be a helpful way to lead off to hear about that before we then hear from the folks who've lived it and benefited from it and are now serving the state on the bench. I want to keep my comments short because, like you, I'm actually looking forward to listening to them talk. But this is a subject that is somewhat detailed. And in truth, I could probably talk for 2 hours without fully exhausting all the details. So I'm going to run through this quickly. If you have any questions, please don't hesitate to see me afterwards or hit me up by email. It's all public information, so you can reach out anytime. So I'm going to talk in just a second about the application. But believe it or not, becoming a judge in California, with rare exceptions, starts with an application like almost any other job. Which is, pretty unique. I remember when I was in law school hearing a judge talk about the judicial appointments process, and someone said, so how do you become a judge? And he said, well, it helps to go to kindergarten with a future governor. And that's not all that helpful, really, for those of us who didn't, at least as far as I know. But the good news here is that in California, I think we've really significantly solved for this problem. This sort of innate influence problem as much as is humanly possible in a political system. And I think that Governor Newsom has taken that even further and has really committed both publicly and privately to the idea of a California bench that reflects his value of a California for all. That is to say, a judiciary that reflects the people of this state. Across every metric of diversity that you can imagine, from race and ethnicity, to gender, to sexuality, to professional background, to socioeconomic background, really trying to make a judiciary that reflects the state. That's sort of the end point here, and I'm going to come back to it. But before we get there, I think it's critical, as any lawyer is thinking about coming to the bench, applying for appointment, that person really stop and think. And that may seem obvious, but I think there's a sense in which, as law students, as lawyers, even just as citizens, we see judges, they seem to be very, they have a certain aura around them. There's a high profile. It's an achievement. It's another feather to put in your hat. And yet, it's also incredibly hard work. And it may take people away from the things that they are naturally predisposed to do. If you came to law school because what you really wanted to do was represent indigent criminal defendants as a public defender, going onto the bench may not only mean losing that advocacy role, but getting into a department that you've never thought was very interesting. And it involves management. It involves a lot of other steps that may not be fresh in your mind as you're sitting in the courtroom or watching judges on television or something. So my strong encouragement is that everybody think first. And there are some great resources here. One of them is a publication. There's this PDF in the slides, which I hope everyone will have access to later. But you can Google this. It's that easy. It's a document called "The Central Principle of Being a Judge and the 8 Pillars" from the California Judicial Conduct Handbook. It's a mouthful. It's actually fairly straightforward. It's about a 12-page document, and I think it can really help a person who aspires to be on the bench to wrap their heads around what it really means to do that, to be a judge, what's important, and to start to think about whether that is a person that you can be. Another great resource that is growing under Governor Newsom, started as a pilot project, is now statewide, is the California Judicial Mentorship Program. And this is something for lawyers who are eligible for appointment, confidentially getting paired with judges who can help them sort out their planning, think about their careers, think about the application process. And this is a way both to create transparency in the process and help people realize that it is accessible. And by doing that, structurally achieve some of the diversity goals that I mentioned earlier. Because if you realize that you don't have to have gone to kindergarten with a future governor in order to be a judge, then maybe you're more likely to apply. And if you're a person that needs to hear that, let me say it, when the time comes and you're ready, if your values match what you see in the 8 pillars, if you're a person who can be objective and fair and can do the hard work and can go into the departments where you're needed, you are a person who should apply. And I say that without hesitation, no matter what your background is, no matter where you went to law school, no matter where you grew up. If you're committed to public service in that way, then this is a job for you. So again, the process really starts with an application. It's a very detailed, long application. There are 74 questions on this application. Many of them call for a sort of essay answer, and they're long and they're thoughtful, and they should be. And so it is something that, on the one hand, there's a simplicity to that, right? You're just filling out an application. Anyone who's had a job has filled out an application. But this is the application of all applications. It really is a monster. And it takes some time, to do it right and to devote the attention to it, to fill out the information, to go through, talk about yourself, talk about your aspirations, why you're a good person, to talk about your cases, to identify the judges you've appeared before, the lawyers that you've worked with and against. It's involved, and it requires some forethought and some real attention. But that is the first step. And then along the way, we're going to talk about sort of what a long process this is as well. As you secure reference letters to support your application, if you have significant career updates, you send them to this email address, which is basically the collection point for my unit, the Judicial Appointments Unit in the governor's office. So the first formal step in nearly all applications is going through what we call our JSACs, our Judicial Selection Advisory Committees. Now, this is a process that nearly every governor, at least to my knowledge, employs, which is to kind of take a first cut on these applications. Look into your backgrounds, look into the people, again, that you've appeared before, that you've worked with, that you've worked against, and then advise the governor's office as to whether you should move forward. There are 8 of them, depending on where you're going to apply. And you can see the list here. Short time, I won't run through them all, but the long and the short of it is that these committees will then advise us a little bit on your background, a little bit on your qualifications, any concerns about you as an applicant, and then we'll rate you either exceptionally well qualified, qualified, or what we would call do not refer, which is basically, I'm going to touch on this in a second, it's really kind of a, this person should probably not move forward, at least at this time. Once we hear back from the JSACs, and I should emphasize, the JSAC process is something that it's a tool that governors use. It is not required. Now, this next step that I'm going to talk about is required by statute. Government Code Section 12011.5 makes it mandatory for governors to submit applications to the State Bar and what it calls the Judicial Nominees Evaluation Commission. Okay, the Jenny Commission, as it's commonly referred to, processes every application for appointment before that person can be appointed, and they go through an extremely detailed and rigorous vetting process where they not only investigate the people on your application, but they do significant outreach to the legal community in the places where you're looking to serve. It is exhaustive, it is thorough, and it is, in the words of now 2 judicial appointments secretaries, the gold standard for judicial vetting, really in the nation. It's a leading organization, and so I want to pause and just make a plug. Once you've been in practice for 7 years, think seriously about applying there too. It's an application to the State Bar to serve on the Jenny Commission. I was on it for 3 years and then chaired it for a 4th year. And it sounds hyperbolic, but it is true. I'm a better person and a better lawyer for the time that I spent serving on this commission, even aside from anything else that I've done. So I strongly encourage it. I also encourage you to take a close look at this section of the government code in the language I've quoted here, which I won't read, which talks about the qualifications for being a judicial officer. So here too, you may start to see a wearing away of assumptions about who a judge should be or must be. Okay, there's a traditional mode of thinking that you have to be a hard-driving district attorney who's tried 100 felony murder cases or whatever. That's not how the legislature has defined judicial qualification. It's not how Governor Newsom thinks about judicial qualification. The key phrase here is looking at a person's legal experience and qualifications broadly. Okay, so take a close look at that. The other thing, as you approach the application stage and start thinking about seeking appointment, I recommend that everybody read the Jenny rules, which are also available through the State Bar's website. It'll give you a sense of the overview. I could talk about that for literally an hour and not run through it all. It's very complicated, but it is all accessible too, and will help you wrap your mind around what goes on. The Jenny Commission at the end, there's an interview with the commission, and they then report to the governor's office. There again, we get a rating for every candidate: exceptionally well qualified, qualified, or not qualified. Now, that not qualified rating is critical because if the governor appoints a person that the Jenny Commission has found not qualified, that fact becomes public. Okay. As far as I know, Governor Newsom has never appointed someone who's found not qualified, certainly not during my time in the office, and I don't believe even before that. It's a very rare thing, though in theory the governor has discretion to do that. There's also an appeals process if you're found not qualified. So again, commend to you the rules. Once we get that report back, that person is now in theory eligible to be appointed. But our office is very thorough. Governor Newsom is interested in judicial appointments. As many of you may know, may not know, his father was a Court of Appeal justice. The governor takes the process of judicial appointments very seriously. Our office takes it seriously. And so we do our own independent vetting confidentially. We speak to people, we hear from people. Sometimes people collar us at parties and want to tell us about people. The long and the short of that is this can be a very time-consuming process. And the only moment in the process where the candidate even knows what's going on, the person who's applied, is during the Jenny process. When an application is before the JSAC, the applicant does not know. After it comes back from the Jenny, the applicant does not know what our office is doing. But the good news is it eventually, for those who rise to the point of being qualified, sort of earning a recommendation from our office, and there being a vacancy that they can fill. They are interviewed by our office. We then take our recommendations to the governor. He decides what to do. Generally speaking, there's a phone call and then a press release that announces the appointment. So that is the applications process, appointments process from beginning to end. And I'm trying to stay within my time. So I think that's it. Again, if anyone has questions, I'm happy to chat after it. Thank you all for your time. It's been an honor.
Good evening, everyone. On behalf of the Latino Law Student Association here at McGeorge, thank you so much for being in attendance today. We'd like to extend our gratitude to our co-sponsors of this event, the YOLO Unity Bar, the Cruz Reynoso Bar Association, the Center for Inclusion and Diversity, the Career Services Office, the Historical Research Society at McGeorge, the McGeorge Black Law Students Association, UC Davis LALSA, Lincoln LALSA, UCLA LALSA, and San Joaquin College of Law Student Bar Association. Lastly, we'd like to thank the justices that have graciously agreed to share their knowledge and wisdom with us today. Before we begin, I'd also like to acknowledge that McGeorge rests on the ancestral and unceded territory of the Nisenan and Miwok people. And with that, I'd like to introduce our Public Relations Chair, Devin Acevedo, for some remarks.
Hello, as Natalia just said, my name is Devin Azevedo, and I'm currently a 3L and the Public Relations Chair for LASA at McGeorge. I'd like to thank you for joining us today in this effort to inspire and encourage diverse law students to pursue a career path towards the judiciary. It's very important that not only the advocates in the courtroom, but also those on the bench reflect the diverse communities that they are serving. And our speakers today are an excellent example of this mission. Until about a few days ago, I was not expecting to make any remarks today, given as Public Relations Chair, I'm more of a background, quiet creative of LASA, who is just doing marketing posts for LASA, but both Natalia and our other co-president, Elizabeth, convinced me to take this space in a way, I guess, to manifest a dream that I have for myself, and that is to be a judge. So I'd like to thank Natalia and Elizabeth and the rest of LASA at McGeorge, who have become a second home for me and never hesitate to support me in any way that they can. As a first-generation Portuguese Latina student, I had no clue what I wanted to do before law school. In fact, I didn't even know what to expect for law school. All I knew is that I wanted to be a lawyer because I wanted to help people. And I've always been taught to never stop chasing my dreams, and I haven't. But when those dreams may not look like me or the comunidad that surrounds me, they can start to feel unattainable. For me, there is nothing more comforting than smelling or eating a hot bowl of pozole or albóndigas, or playing dominoes with my abuelo, or just a warm embrace from my abuela. But when I see someone from my comunidad attaining the same dreams that I have for myself, I tend to feel that same comforting feeling. And truly, that's what keeps me going. So whatever comforts you and ignites that fire in you to keep going, I hope that you feel that after our time here today. Thank you.
And with that, I would ask panel A to come up. As a quick introduction, think we got the orders mixed up here, but give me a sec. We have Judge David Munoz Figueroa, currently serving Fresno County Superior Court. To his left is retired Judge Emily Vasquez of the Sacramento County Superior Courthouse. And to her left is Administrative Law Judge Alberto Rosas for the California Public Utilities Commission. And with that, let's begin. Judge Munoz, can you remember the moment you decided to become a judge? Was becoming a judge something that you ever saw yourself doing?
Thank you. Thank you for having me. Thank you for having us. Welcome, everyone. I'll start with the second question first. No, it's not something I ever thought that I would be doing. I absolutely loved my job as a public defender. I was very happy. I was a chief defense attorney of the major crime unit for several years. And when I decided to become a judge, it wasn't overnight. It was a long, long process. It took me about a year to think about it. And I was eligible after 10 years, but again, it never crossed my mind. It wasn't until maybe the 14th year of me being a public servant, a public defender, that a very well-known and respected judge, she is now retired, tapped me on the shoulder and said to me, have you considered applying for the bench? I think you have a lot to offer, those sort of things. She said to me, you'd be great, and hyped me up. And I believed it, but my initial response was, no, absolutely not. I love what I do. I help a lot of people, and that's why I wanted to become a lawyer. And she said, I understand, but as a judge, you'd be able to help a lot more people and on a greater level. But still, I wasn't convinced. I put it away, and I kept thinking about it. And it wasn't until I started attending events like this and hearing others speak about what Governor Newsom was looking for, and he is looking for diversity on the bench. I'm Exhibit A for that. I heard Secretary Cespedes speak at least 4 events. See Jesse Morris here. Thank you, Mr. Morris. I saw you personally make trips to Fresno on 3 different occasions. And I want you to know that your words truly, truly inspired me. Thank you. When I heard the speakers speak, they talked about diversity. They talked about not just cultural diversity, professional diversity, personal diversity, things that people went through growing up, things that people overcame, barriers. And my wife and I were at these events listening to people speak. And she said, wow, I think they're talking about people like you. She even said to me, you check all the boxes, good work ethic, you care, you're a public servant. She tapped me on the shoulder or elbowed me and said, están hablando de ti, menso. That means they're talking about you, dummy. They're looking for you. So then I get hyped up again, and about 15 years into my career, I decided to take a look at the application, and it's very long. I think it's about 50 pages, and not kidding, it's single-spaced, 8-point font. And I went through it, and I said, you know what? Never mind. Just kidding, right? No, I filled out the biographic information, then put it down for several months, then filled out the next section, put it down several months, and I wasn't getting anywhere with completing it. So I decided to take a week off work to finally complete it, and I did. And once I did, I'll tell you, my colleague here made it sound like a terrible process. I really don't think it is. It was fun for me. It was fulfilling. I got to talk about my career, what I've done for the last 17 years. If you ask a lawyer to talk about himself and what makes him a great attorney, believe me, they're going to take the chance. I think I did 3 interviews, 7 hours between the interviews, and I felt I was in Disneyland or Magic Mountain for those who don't like Disneyland. But again, it was a fulfilling process. We can talk about it later because I'm out of time. I absolutely enjoyed every single moment, and I encourage you to think about it. We'll talk more in a little bit. Thank you.
And Judge, thank you. Judge Vasquez, everyone's pathway to the bench is different. What are some obstacles that you faced on your journey to the bench, and how did you overcome them?
All right. Well, I will tell you that a career as a judge never occurred to me. I didn't go to law school thinking that this would be my end game. It never crossed my mind. It was an elusive position that I never considered. When I attended law school, there were no Latina judges on any state or federal court in California or the nation. I never imagined that I'd be a judge. In 2001, when I was appointed to the Sacramento Superior Court, I applied like Judge Munoz at the encouragement of some judges that I had tried jury trials in front of as an assistant public defender and as a civil litigator. Prior to my appointment to the bench, I had handled dozens of jury and bench trials in criminal law and civil law. So I was fortunate that my transition to the bench was an easy one because of my experience. But no, the difficulties for me were the financial obstacles that I encountered in trying to attend college and law school. As the daughter of poor immigrant, migrant farm workers, my parents had no money. They could not support me financially or otherwise. Also, they didn't really understand the value of a college education. They didn't understand how it could open doors of opportunity because they had never had any formal education. They knew no one in their community that had ever gone off to college. So college was unheard of in my family and in my community. College was a pipe dream. Besides, in my world, no one left to go to college. We were lucky if we were able to graduate from high school. One of the biggest obstacles that I faced and that poor students of today face is that we have to overcome the fact that we have no financial safety net. I will tell you that all through college and law school, I experienced the feeling of standing precariously close to the ledge, that any unexpected expenditure or expense would completely derail my entire education and my future. And so what I did to prepare for that was that every summer, from my summer job, and I know we all have summer jobs, I would squirrel away several $100s in a little savings account, just in case there was some unexpected expense that arose during the school year. And I'm so glad I did that because indeed, my junior year in college, I faced a financial obstacle, and I was so fortunate and so happy that I had some money, a little bit of money in my savings account to deal with that unforeseen expense. And I know that for first generation students of today, a broken computer, a broken phone, a broken car can become an insurmountable obstacle. And all students need these items. You need them to take your examinations. You need them to get notifications from prospective employers. You need them to travel to job interviews. I will tell you that I was hyper aware of my finances all through college and law school. And yes, it was stressful, but you have to be that way when you have no money because you don't want to take on additional debt. And that's only if you qualify for a loan, but you don't want to take on additional debt if you can avoid it. But let me tell you that it was all worth it and much more. It is so special and such a privilege to be able to use your law degree to meaningfully improve people's lives. Throughout my career, which is now more than 45 years, it went by so fast, I had the privilege of meeting some excellent, remarkable, outstanding lawyers and judges, many of whom are in this room here today. And I will tell you that I found tremendous, tremendous satisfaction in my career as a lawyer and a judge. Thank you.
Thank you. And Judge Rosas, what is an administrative law judge and what are the requirements to apply?
Administrative law judges, or AOJs, are judges that preside over hearings of administrative disputes within federal or state agencies. Because they only hear issues concerning administrative law, they are members of the executive branch, not the judicial branch. Administrative law judges participate in many different areas of law, and they work for many different agencies. At the federal level, for example, you will find AOJs that work for the Social Security Administration, the Environmental Protection Agency, the Postal Service, and many others. For the last 6 years, I have had the honor of serving as an AOJ for the state of California. And here in California, you will find AOJs at multiple state agencies, such as the Department of Motor Vehicles, the California Department of Social Services, the California Public Utilities Commission, which is where I work. And you will also find AOJs at a state agency that is of particular interest to California attorneys. I'm referring to the State Bar of California. Let's say that someone lodges a State Bar complaint against an attorney. The State Bar will investigate, and if they determine that charges are warranted, a State Bar prosecutor will present that case before an AOJ. And it is that AOJ who will decide whether to recommend disciplinary actions or whether to dismiss those charges. Each agency in California is slightly different. At my agency, for example, I preside over evidentiary hearings and I make determinations based on questions of fact, questions of law, very similar to a bench trial in the judicial branch. I have the authority to issue sanctions, subpoenas, rulings. I can discuss case settlement or mediation with the parties. I respond to evidentiary objections during witness testimony. And at the end of the day, I try to control the proceedings before me so that I'm able to balance due process with the efficient adjudication of these cases. At my agency, our decisions are appealable to the California Court of Appeals. But at some agency, there is no direct right of appeal. Rather, the losing party would have a right to seek a trial de novo with the California Superior Court. Now, when it comes to how to apply to these positions, administrative law judges are not appointed, they're not elected. The application process is not as long as what you've just heard. And even though at each state agency, the application varies slightly, the overall general application process is very similar to someone applying for an attorney position at that same agency. The biggest difference, however, is that whereas many of these state agencies do many of these state agencies do hire right out of law school. For these AOJ positions, they do require that you have at the minimum at least 5 years of legal experience practicing law. Thank you.
Thank you. And Judge Munoz, what are some common mistakes you see lawyers make in your courtroom?
Thank you. I'll say for the most part, if you have a bar card, you know what you're doing. I am blessed with a good staff of attorneys from I should have said this, I do a misdemeanor calendar. So the attorneys in my courtroom are 2 from the prosecutor's office and 3 from the public defender's office. And I am blessed to have an exceptional staff. I emailed them late last night and I said, hey, we need to finish by 12 at the latest. And we had maybe 75 cases on calendar. I told them that I needed to get on the road to talk to you folks. And we finished at 10:30. And we didn't speed through anything. We were just more efficient, no breaks. We needed to get done. We did what we needed to get done. That being said, there are some attorneys, usually for some reason, it's out of town attorneys that come into my courtroom and I see them make common mistakes. A lot of times they don't know what a case is worth. They don't know the procedure. Sometimes attorneys file motions that I think should not have been filed, and I don't know why they're filing them, but we need to process every motion and give it its due attention. I don't like when attorneys argue just to argue sometimes. If you do that, you lose credibility when there's a real issue before the court. I think newer attorneys don't take cues from judges. A common cue is when you lean forward and you say, submit it. That means that I'm done listening, I'm ready to rule. Or sometimes, depending on how you do it, if you smile, they might that's telling them, oh, you've won your motion, submit it. That means you're ahead. I have to literally tell attorneys sometimes, counsel, you're ahead, meaning stop, I'm going to rule in your favor. Another one, here's a cue practice tip. If you make an objection and the court overrules it and says overruled on those grounds, that means there's a legal objection, you just cited the wrong one, the wrong legal basis. So think about that. One of the common mistakes that attorneys make is when I overrule an objection, they move on, they abandon it when it's a crucial issue. So don't do that. Just think on your feet and be ready to go. You could have a list of objections there at counsel table. See a couple more things. I see some attorneys not act professionally, and that really bugs me, especially when they're being rude to their clients, to each other, opposing counsel. I think that if you develop a reputation of someone that tries to be a bully, that follows you for the rest of your career. And if you're here, you're interested in being a judge, unlike me, that, you know, it happened later in my career. So know that your reputation follows you for your entire career. And people remember, judges have long memories and judges talk with each other. We have meetings on a regular basis. So we know the repeat offenders. Let me check my notes here. Then there's other things that might bug me. For example, we are really busy. Usually we have over 100 cases Monday through Wednesday. And if we're on the record, people being loud or approaching the clerk, poor clerk, he needs to take everything down that I'm saying. And yet that's happening. Different things. I'm almost out of time. What I'm doing in a few weeks is I'm going to have a brown bag lunch with the attorneys in my courtroom to talk about some of the issues and get feedback from them. We can all learn from each other. We work as a team. We're all public servants and try to do good by the community. So we'll see how that goes. Thank you.
Thank you. And Judge Vasquez, how does having judges of different backgrounds and experiences enrich the court?
Well, first, I want to say that in every case that we judges handle, the law is our guiding light. We apply the law to the facts as we determine them to be, and the law is the bedrock of our legal analysis. But yes, it is critically important that the legal profession and the judiciary reflect the population of this great state in order for the public to truly respect this governmental institution as protecting its individual rights. Having a diverse judiciary is important for the same reason that the United States Constitution protects the principle that juries reflect a fair cross-section of the community. A diverse jury is an important safeguard against bias, and it ensures greater participation, greater thought, and more balanced deliberation. And for many of the same reasons, it's important that judges who are called upon to pass judgment over the lives of others, these are important decisions. It's important that judges reflect the broad human experiences of all the communities that we represent. When you have a diverse court, just like when you have a diverse jury, the idea is that you have a better decision-making process, and in the end, a better decision. And it also leads just to a more fuller discussion. You bring a variety of perspectives, a variety of ideas, a variety of ways of looking at the issue. And I know that all of us know that in order for our courts to function, we must have the trust and confidence of the people that we serve. A more inclusive justice system is a fairer justice system because a diverse judiciary, a diverse justice system reduces implicit bias and leads to a better decision-making process and a better decision in the end. And at the same time, a diverse judiciary provides role models for those that have been historically excluded from it. As Justice Sandra Day O'Connor explained the impact that Justice Thurgood Marshall's background had on United States Supreme Court decisions. She paid tribute to him in 1992, and she recounted how Justice Thurgood Marshall fondly shared his personal stories with the other justices in conference in order to make explicit legal points about cases that were before the court. And he told them personal stories about the Ku Klux Klan violence, about jury bias, about representing an innocent African-American man that had been wrongfully convicted of rape and sentenced to death. And he also told them of many indignities that he endured due to racial segregation. And Justice Sandra Day O'Connor spoke about the impact that these stories had on her in better understanding the legal issues that were confronting the U.S. Supreme Court. She spoke about the impact of legal rules on human lives and how judges and the need for judges to strive to narrow the gap between the ideal of equal justice and the reality of social inequality. And then in reading Justice Thurgood Marshall's biography, it was noted that in criminal cases, whenever there were criminal defendants, that Justice Thurgood Marshall was quick to remind the other justices that he was the only one who had ever been arrested, handcuffed, and ended up on the wrong side of the interrogation table. Quite simply, diversity brings many voices to the table, a variety of perspectives, a variety of ideas, a variety of thoughts, voices that might not otherwise be heard. Thank you.
Thank you. And Judge Rosas, how do you handle incivility in and outside the courtroom?
A judge shall require order and decorum in proceedings. Incivility is an unnecessary distraction that adds nothing to the legal discourse, and it distracts the parties from addressing the real issues in dispute. I want to quote my dear friend and mentor, Judge Emily Vasquez. In the past, I have heard her say that incivility hurts your reputation, it hurts your clients, and it hurts the legal profession. As an administrative law judge, I want all the parties who appear before me to walk away knowing that they were heard and that the process was fair. Civility and mutual respect are essential to accomplish that goal. I try to handle incivility by doing two things: by curtailing incivility, but at the same time, modeling civility. It is important to curtail incivility because you should not let it go unchecked. You shouldn't ignore it. You have to address it immediately, because as part of requiring order and decorum, it is important to send a message that incivility will not be tolerated. And as part of that message, it is important to convey expectations. When the parties appearing before me are self-represented litigants, I explain to them what I expect from them. I explained that my proceedings are not going to be an episode of Judge Judy. I expect them to treat everyone with dignity, courtesy, and respect. That includes court staff, the stenographer, interpreter, witnesses, and each other. As a last resort, I do have the authority to issue sanctions. Now, I've never had to issue a sanction, but sometimes the mere threat of a sanction may be sufficient to help curtail any further acts of incivility. When it comes to modeling civility, it is important to try to model the type of civility that you want to see. I try to treat everyone with dignity, courtesy, respect. That includes the attorneys, the parties, the witnesses, the court staff. A judge should model and practice civility by having a good judicial demeanor, by being a consummate professional on and off the bench. And lastly, I want to say something about civility in general. I recognize some of my students here in the audience, so I want to make a statement to the students and the attorneys. I want you to know that incivility, strike that. I want you to know that civility is not inconsistent with zealous representation. You can be a zealous advocate and still treat everyone with dignity, courtesy, and respect. And in your careers as advocates, sometimes you will face incivility from your friends across the aisle. Though you cannot control their actions, you can control how you choose to respond. When they go low, you go high. Never lower yourself to their level, because you do not fight fire with fire. You fight fire with ice. Ice. I-C-E. Integrity. Civility. Ethics. ICE. Thank you.
Thank you. And Judge Munoz, what is the best advice you received in your legal career, and how do you apply it in your everyday profession?
Thank you. I received a lot of advice throughout my career. I tell this to people that I used to interview, and this was what I would tell my children. A friend is to start a career, I highly recommend that you start as a public defender or a prosecutor, and the reason is you're going to get a lot of trial experience, and that experience is essential to a successful legal career. You learn the laws of evidence, you know how to keep evidence in, or how to introduce evidence, how to keep evidence out. And I agree with my colleague, the Deputy Appointment Secretary that spoke to you earlier, that it's not the end all, but it certainly doesn't hurt. And when you speak to a trial, with a trial attorney, they almost speak a different language, and you're able to know, okay, this person's tried cases, and they have a lot of credibility with their client, with opposing counsel, and with the court. Another piece of advice is know that you don't litigate every case in the same manner. Know when to adjust your sails. So know that some cases it may require a hardline stance. In other cases, I may want to slow down a bit here. Let me continue the matter. The prosecutor or opposing counsel is being unreasonable. Let me continue it out, investigate the case, and see if we can come to a better resolution down the road. Another piece of advice is I want to echo some of what my colleagues said, and treat others how you want to be treated. And this is what I think is I know that's my responsibility as a judge. And when you're an attorney, just think about it. If a family member gets arrested, if you, God forbid, get arrested, a former president is on trial now. None of us are immune from prosecution, but just think about, how do you want to be treated? Do you want an attorney that's rude, that doesn't listen? You don't want that. So if you practice the golden rule, treat others how you want to be treated, you'll be ahead of the game. And I couldn't agree more with my colleagues. that you need to protect your reputation. I received this advice early on, and I firmly believe it, that it takes years, several years, if not decades, to build a good reputation, but you could lose it in one instant. You could lose it in one case, one issue of the case. And again, judges have long memories. Don't file frivolous motions. Don't be deceitful with the court. Be kind to the other side. And something you said, Judge, and it reminded me of something, is you're absolutely right that you don't have to be people's best friends. You're going to get people upset, opposing counsel upset. If you don't do that, you're probably not being a good advocate. You're going to ruffle some feathers, but that doesn't mean that you should be uncivil, that you shouldn't be courteous. You should. It might work on one case where you bully someone into agreeing with what you want to resolve the case for, but in the long run, it's not going to work and you're compromising your reputation. The last thing I wanted to say on this topic is follow the golden rule and you'll be okay. We try to do that as judges. I try to do that during my career as an attorney, and none of us are perfect. But if you strive for perfection and take every day, day by day, learn something new every day, I think you'll be perfectly fine. Thank you.
And Judge Vasquez, what is the most egregious courtroom behavior you have witnessed, and how did you react?
Well, during my 20 years on the bench, I presided over close to 400 jury trials in civil and criminal law. In the criminal context, I presided over trials ranging from misdemeanor driving under the influence to a 5-defendant gang murder case. In the civil area, I presided over unlawful detainers, limited jurisdiction cases, all the way to complex civil litigation, class action lawsuits seeking millions and millions of dollars. Whenever you deal with taking people's liberty, property, family, children, which are the issues the courts deal with, those are highly charged, emotional, passionate cases. And during my time on the Superior Court, I did encounter hostilities expressed by defendants against their attorneys, hostilities expressed against our justice system, and occasionally against the court. And there were certainly occasions when attorneys, in the heat of battle, in an adversarial hearing or trial, tended to be a bit more aggressive with one another verbally. What I did was I would take counsel into chambers outside the presence of the jury, and I would advise them to lower the temperature. I would advise them the proper way to present their effective arguments to the court. I would advise them how to address opposing counsel, to not be hostile, but they could be just as passionate and strong in their respective positions. Frankly, I told them that incivility detracted from their effective arguments, and they weren't making any points with the jury. And so, and I advised them that I expected all counsel and parties in my courtroom to treat each other with respect, even if we strongly disagreed with one another. And as a judge, and I think it starts at the top with the judge. As a judge, I tried to create an environment where everyone was treated with respect and dignity. And I set that example, and I expected that of my staff. I listened very thoughtfully to all the arguments presented by counsel, to all the arguments presented by improper litigants. And I feel very strongly that the ability to manage one's courtroom is a critical skill that judges need to have. You need to create an environment that is safe, where everyone feels safe telling their story. And in order to set that standard, set that tone, create that environment, that starts at the top with the judge. And I think also the manner in which I address persons, the people in my courtroom set a tone. I addressed everyone, jurors, witnesses, attorneys, parties by their last name. I never just simply said the criminal defendant, never said that, always addressed him or her by their last name. And regrettably, I know some of my judicial colleagues do not do that. And that was important to me. Also, I think the promptness in the way I ran my hearings and trials showed an appreciation of their time. And I will tell you that during the 20 years that I was on the bench, I never even came close to holding anyone in contempt.
Thank you. And Judge Rosas, what makes you a good judge? Or what makes a good judge? Sorry.
I grew up in the restaurant industry. My father was a successful restaurant owner and chef, and I started working in the family restaurant when I was 13 years old. The restaurant industry is about customer service. Being a judge is about public service. And there are three things I learned running a restaurant that I still apply to this day in my work running a courtroom. Number one, no matter who walks through that door, everyone deserves respect. Number two, you can't run the operation by yourself. It takes a team effort. And number three, mistakes will happen. When you make mistakes, own up to them and fix it. I want to stay with this restaurant theme. So here is my recipe for what makes a good judge. First, you need to make sure that your kitchen is equipped with a cookbook and a working fire extinguisher. The cookbook is the code of judicial ethics. The fire extinguisher is because, well, you're going to make mistakes. Food safety is critical. You want to make sure that your cooking area is clean and sanitary. That means you want to get rid of any assumptions. You don't want to assume anything. You want to avoid any bias or prejudice, and you definitely want to get rid of your ego, because this is not about you. You want to avoid impropriety and the appearance of impropriety. When it comes to the main judicial ingredients, they include honesty, integrity, civility, ethics, judicial demeanor, awareness, and mindfulness. Always be mindful of the fact that you are a judge on and off the bench. Righteousness, courage. Sometimes as a judge, you will be called to make tough calls. Make a decision based on the law, even if that is not the popular choice. You should never decide a case out of fear or favor. Always have the courage to do what is right. Uphold the integrity and the independence of the judiciary and perform your duties impartially, competently, and diligently. Now for the special sauce, or what I like to call the Socratic sauce. Socrates said that 4 things belong to a judge: to listen courteously, to answer wisely, to consider soberly, and to decide impartially. Then you put it all in the oven, and like a good barbecue, you cook it slowly, because patience is a virtue for judges. You need to be patient with the parties, but also be patient with yourself, because it takes time. It takes time to transition from being an advocate to being a judge, and you will make mistakes. Hence, the fire extinguisher. And then we get to the dessert, because this main judicial dish is best served with dessert, and the best dessert is a big slice of humble pie. You need to be humble. Humility is what anchors all the other judicial ingredients together. Humility means recognizing that you are accountable. Humility means knowing that you can make mistakes. Hence, the fire extinguisher. Thank you.
Thank you. Can you please give a round of applause to panel A, who's just been amazing tonight? We will now have a quick intermission to switch to panel B. Please feel free to use this time to stand up and get the blood flowing again. We also have refreshments, light refreshments in the back, and also anyone who needs to use the restroom.
You want to sit on the end or you want to sit? Yeah, okay. Let her sit in the center.
Thank you. And as a quick introduction, to my left is Justice Rosendo Pena of the 5th District Court of Appeal. To his left is Judge Mary Vasquez, currently serving Fresno County Superior Court. And to her left is retired presiding Justice Arthur G. Scotland of the 3rd District Court of Appeal. And with that, let's begin. Justice Pena, can you discuss the importance of judicial independence and impartiality and how you uphold these principles in your role?
Thank you very much for that question. It kind of blends in with what Judge Ross was already talking about earlier, about what makes a good judge. Impartiality and judicial independence are two very important aspects. I think everyone on this panel and on the earlier panel would agree that it is very important. So what does a judge do? Some have described that as simply a person calling balls and strikes. I don't know that I would agree with that description, but it does require that the person who is sitting as a judge be neutral, that he or she be impartial. And what does that mean? To me, what it means is that you come into a case without any preconceived notions or any bias, either for a party or an issue that it comes before you. Instead, you look at the cases that come before you, the parties come before you, as persons that have strong points on either side. You have to decide which side has the law on their side. You also have to decide where the facts lie. These are all very important to then try to make an impartial decision. Now, it was also mentioned that you have to take off the hat that you may have come in with before you became a judge. Now, you need at least 10 years as an attorney in California before you can actually become a judge. And during that time, you're going to be perhaps in one area of law, for example, the public defender's office, district attorney's office. And so you've been an advocate on one side for many years. When you take on the robe, the hat of the judge, you have to put all of those prior advocacy and bias maybe that you may have had in serving your clients, and again, become simply a neutral person that has an open mind and listens to both sides. One of the things that parties really expect from you, not only this impartiality, this non-bias, but to listen to them, to listen to what they have to say, and before you make a ruling, and don't shut people off because you've already kind of made up your mind. That's the last thing that they want to see. In the same vein, we're talking also about judicial independence. And I think, again, Judge Rosas touched on it a little bit in his last answer. And this also is very important for a judge. When you have a case, you have parties that one party may be stronger in terms of, or may have more influence. You're not to consider that and thinking, well, maybe I need to rule for this person. No, you have to independently look at all of the facts and also independently determine what the correct rule of law is, and do not be concerned with public opinion. A lot of times there are cases that come up before a judge, especially I think in the trial courts. And again, it was mentioned before by Judge Rosas, you have to have courage in order to make proper decisions, because there is a situation sometimes when you know that a decision that is correct, you have to essentially make as an impartial judge, may not be the popular decision. And in fact, unfortunately, there have been situations where judges have made an unpopular decision only to later on get challenged and actually be defeated at the election because they had the courage to stand up for what they believed. And so it does require courage. It does require the ability to block things that really are extraneous to the case itself when you're considering the rules of law and the facts. Now, I think there's another aspect to judicial independence. There's the fact that the judiciary is the third branch of a three-part system of government that we have here in California. And that is, you have the legislative as well as the executive branches. The judiciary is an equal member of those branches, and we have to maintain that independence from these other two branches. We're not to be swayed or in any way allow the legislature or the executive branch to dictate or lead us to make certain decisions because that is how they want to see it done. Again, we have to maintain a complete independence from these other branches. That is what is required of us by the Constitution. So how do I do impartiality, independence? So I've been both a Superior Court judge for 10 years and now I've been an appellate court justice for 11 years. And they're two very different roles. As a trial judge, you're basically an island. You make decisions on your own. And when you're on the appellate court, all of our decisions are based on a three-judge panel. And so there is no situation where you feel like you're alone. You at least get to speak with the other justices about the case. That I think helps matters out. But when I approached the cases as a trial judge, my main concern was have an open mind, do not have any preconceived notions about how the case should be decided, and listen to the parties. And that's what I tried to do. And I think for the most part, I thought I was successful. I felt that some of the comments that I have received is that, you know what, you always listened. I didn't agree with you every time, but you listened and made thoughtful decisions. With the work that I do now at the Court of Appeal, we also have research attorneys that help us to make our decisions. They prepare what are called calendar memoranda to advise us what the law is, what the facts are based on what happened in the lower court and the trial court, whether it was a trial or some other proceeding. And the way I try to keep judicial independence and impartiality is I let them know that whenever they look at a case from the beginning, to not think about, whether the case, whether there'll be any repercussions or whether they should be thinking of affirmance of the lower court judgment or reversal. I let them know in advance. You give me your independent view of the case. I'm going to review everything in any event and make my own decision, but I do rely on them quite a bit for their services that they do provide. And so that's one way that I try to maintain that impartiality. And as far as independence, as I mentioned, when on the appellate court you have three judges, well, I don't always agree with the other two justices. And although we always are looking to try to reach unanimous opinions if we can, try to agree on what the decision should be, I don't, and I don't think the other justices on any of the panels, at least the justices that I've served with at the Fifth District, really view their job as something you just have to follow what the other person asks or says. And to me, that is part of the judicial independence aspect of my role, and that is to give my opinion if it does not coincide with that of the other justices, whether it's in a dissent or in a concurrence, because even though sometimes we agree on the outcome of a decision, or what the outcome should be, our concurrences allow us to disagree about the manner in which we get there, to disagree perhaps about certain parts of of how a statute should be interpreted, constitution should be interpreted, or when we disagree on the outcome, perhaps that idea that maybe this decision was harmful to the party in the error that the judge committed, and so it does require that we reverse. And if the other two members do not agree that it should be reversed, it doesn't keep me from saying no. This is my view of it, and if it were up to me, I would reverse the judgment in this case.
Thank you. And Judge Vasquez, in your legal profession, have you ever experienced a time you felt you were treated differently, either because you were a Latina or a woman? And how did you respond to those situations?
So yes, yes, I have. That experience is unfortunately, it's not a unique experience. I know many who have been mistaken for the clerk, the interpreter, the victim's advocate. My first week on the bench, I was all three. I got carded regularly as I walked through the halls. But I want to start by sharing my first experience with that, I think, in the legal profession. I'm feeling a bit courageous, thanks to Justice Pena's answer just now. When I was a 1L, my first semester year, I was very proud of myself. I had prepared diligently for a moot court argument. I went to present that argument. I had just bought new clothes. I remember they were from Target because I was still kind of learning my way through how to dress professionally, but I was really excited. And I presented an impassioned argument. And at the end of it, the attorney looked at me and said, I can tell you're a little bit ghetto. You're from the streets. And I sat there shocked and wasn't even sure how to respond in that moment. I think I took the feedback. I walked out. I was emotional, and it took me a long time to be comfortable presenting again. So I'll fast forward from that moment until now. The way that I respond to these situations now is to try to use that moment to educate people. And so while it's not my responsibility to highlight or to educate on issues of explicit bias, microaggressions, implicit bias, it is an opportunity. And if I can take the courage to use that opportunity to have a conversation and to open that dialogue so that maybe they don't respond that way to a new 1L student, then I will have felt like I was able to take what could have been a very disastrous situation and made some good of it. So I will say that now I'm pretty direct about those confrontations. I give a lot of grace in them. I tend to use humor to kind of start the dialogue a little bit. I know that when people have asked me, are you the court interpreter? I'm like, no, just the judge. And so that's how I'll start that dialogue. But it gives people an opportunity to just reflect on their own comments and maybe their own implicit biases. So again, I like to use them as opportunities and hope that I can transform the dialogue in the legal profession and in all professions so that perhaps those biases aren't as evident in years to come.
Thank you. And Justice Scotland, what role do mentorships and professional networks play in your judicial career? And how can law students leverage these resources to navigate their own paths?
Well, thank you, Joshua, for your very insightful question. Mentors played a major role in my career in the law. In fact, without the good fortune of having a number of really wonderful mentors, I am sure that I never would have become a judge. And mentorship really comes in a variety of forms. For example, in my first job as a lawyer, it was my seeking out and receiving advice from colleagues in the district attorney's office about how to become an effective and respected prosecutor. And a few years later, it was the advice and encouragement that I received from a friend and a former McGeorge classmate who encouraged and then convinced me to become an attorney in the criminal law division of the California Attorney General's office. And it was a difficult decision, very difficult decision. But in retrospect, it turned out that that was the turning point really in my serendipitous pathway to the bench. In the Attorney General's office, among the mentors I had there, my truly life-changing mentor is Stephen Merksimer, who is a brilliant attorney with a background in politics, who had become a special assistant to Attorney General George Deukmejian after I had joined the office in the former administration. And Steve later, after Attorney General Deukmejian successfully ran for governor, he became the chief of staff, which is the most significant position in the governor's office other than the governor himself or herself. But he became chief of staff, and now he continues to be a very respected and admired attorney at the Nielsen Merksimer law firm. And after he took me under his wing, he taught me a lot about and got me involved in a number of very significant government law cases with public policy implications. And I learned a lot from him. And then when Attorney General Deukmejian ran for governor, Steve asked me to take a leave of absence from the office to work in the policy office of the campaign, which I happily did. And then my candidate won, and because of Steve, I became the cabinet secretary to Governor Deukmejian, which was just a remarkable experience, learning about the massive role, the breadth of the role of state government and dealing with the members of the cabinet and all. It was just that was a life-changing experience. And then, of course, I had the good opportunity to work with Governor Deukmejian, who truly was a remarkable mentor and role model for very thorough and principled decision-making, and also for learning about wonderful leadership skills. That 4 years truly changed my life, and I learned so much from him about what it takes to be an objective, fair and thorough judge. I could go on and on about my mentors on the bench, including presiding Justice Robert Puglia, then initially judge and now Justice on the Court of Appeal Ron Roby and others. But really the point of my somewhat long-winded answer is really that all of you, the law students in this audience, should try to take advantage of, try to develop mentors, and those mentors and be involved in some professional networks. They will help you guide your pathway in the law. And, for example, joining a local American Inn of Court, like the one here in Sacramento, the Anthony M. Kennedy American Inn of Court, the one in Davis that Justice Meziwala has been the president of. These are organizations of judges, attorneys, and law students dedicated to promoting civility, ethics, and professionalism in the law and excellence in the law. And by joining an Inn of Court, you will meet and get to know and receive the benefit of mentorship from a broad group of attorneys, judges, and others. It's just a remarkable experience. Do that. Another way to develop and get some mentors is to join a local bar association and then specialty bars. There are a number of ways to get the benefit of mentorship. But simply put, mentors are going to help make your pathway in the law smoother and in the best direction. Okay.
Thank you. Justice Pena, as a former president of La Raza Lawyers Association, Fresno Division, what advice would you give young Latina law students that feel that they don't belong in this profession, i.e. the imposter syndrome?
Well, first of all, I want to say that I think it's natural for persons to have some measure of self-doubt about the unknown. And I guess I'm a prime example of that. You heard Judge Emily Vasquez talk about she grew up in a farm worker family, while I was also from the Valley, Parlier, California, down in the middle of near Fresno. And both of my parents were farm workers. And the reason I bring that up is that at some point I knew that I wanted to be a lawyer. The problem was I didn't know any lawyers. I didn't have any mentors or anyone really that could help guide me about what I'm supposed to do to get to the point that I wanted to be. And so yes, and if you're in that boat, yes, you might have some self-doubt about whether you will get there, because maybe you don't know enough about the law or anything regarding the law, maybe what you've seen on television, which is basically what, and back when I was growing up, there weren't a whole lot of programs on television, so there weren't, all these law type of miniseries and weekly events. But in any event, I think what I did to try to deal with that is what we're just talking about here with Justice Scotland, and that is joining groups that are folks essentially in the same boat as you. I always was a member, if I could be, of any specialty student associations going into college and then in law school. In fact, at Fresno State, which is where I went to undergraduate, there was nothing like that. And so I, along with a number of other pre-law students or students that really wanted to go to law school, decided we needed to form an organization, a club that we called the Chicanos in Law, and which served a really important purpose for those students that came after us, because it was an important organization that provided information, brought folks in from law schools, and brought lawyers in to talk to the students. I've given speeches, obviously, to some of those students after I became a lawyer. And so these associations are very important. They help you to understand that you're not alone in the way you feel, all right? So if there's a little bit of self-doubt, it's not really a big problem. I went, to school with other students like myself at UCLA, and for most of us made it through. Most of us are lawyers or judges, very successful in different areas. So you want to have some self-confidence that that's going to be you in a few years. And so we've heard mention here, Judicial Appointment Secretary Luis Cespedes, and I think, as a matter of fact, he had maybe some kind of a seminar this afternoon for attorneys, and he speaks to different attorney groups because he wants to encourage them to apply to become judges. And he talks about the imposter syndrome, that we have a lot of very qualified attorneys that simply are not applying. Why are they not applying? And I think it goes to the idea or the notion that maybe they're feeling that they're not there yet, not completely prepared. Again, self-doubt creeps in. And so that unfortunately will discourage some to not apply. What I'm going to say to you is, don't worry about that. You have to believe in your abilities and you have to keep moving forward. If you want to become a lawyer, you will become a lawyer. If you want to become a judge, there's a really good chance you will become a judge if you listen to some of the things that we've said. And even as attorneys, when you first become an attorney, again, you want to look for resources that are available to you. Okay, and again, Justice Scotland was mentioning some of those mentorship type programs or folks that become mentors for you. Well, even before you get there, think about, so what do attorneys do? How do I learn about that? I think one good way is to take summer jobs at a law firm or internships, even if they're unpaid, so that you get an idea of what lawyers do. So it lets you know that, hey, maybe I can do this. And I'll give my own personal experience on this. When I was second year, I decided to apply for an externship with the State Public Defender's Office in Los Angeles. And so what I did is I was able to work for 3 months during the summer and also took a semester off and worked an additional 3 months. So I had a whole 6 months of experience where I worked in a law office, worked with lawyers, and I actually wrote briefs. The State Public Defender's Office did appeals. So that's why I first got into appeals and became a research attorney later. But after I had that experience, I had much more self-confidence. I kind of knew, okay, this is what lawyers do. I think I can do this. And so I think those are things that you should be looking to even as students. And when you become attorneys, you should know that law firms and public agencies such as the Public Defender's Office, District Attorney's Office, they offer things like training programs for their new associates, their new attorneys. Okay, so you're not going to be out there just like, oh, I've read about contracts, I read about constitutional law and real property. How do I apply that in the real world, right? You don't really have any ideas until you see it in action at a law office. So don't be concerned about that, because there will be experienced attorneys that can guide you. They can be serve as mentors. And getting also to the Raza Lawyer Association, I became a part of that because I had moved from Los Angeles back to Fresno and I didn't know anybody, any lawyers there. So this was a good way for me to become acquainted with other attorneys that were essentially in the same boat as I was. Some were new, some were more experienced. Gave me the opportunity, if I had questions about things that I hadn't learned yet, I had the opportunity to ask those folks. And so, and there are other specialty type of bars that you can join if they are in your area of law that you're practicing. You want to also participate in those because, again, there's things that you can learn from the other attorneys, things that you can learn from the training classes that they will present. And you will have continuing education for the rest of your life as a lawyer. I can tell you that. Even as a judge, we do continuing education.
Thank you. And Judge Vasquez, what are the pros and cons of your job? And would you recommend others to be a judge? Why or why not?
Thank you. So I'll start by saying that I am fairly new at my job. I am still finding my footing, but I absolutely love it. And I will say that it has been an incredible experience. And I love my former job. I was also a chief defense attorney at the Public Defender Office. I worked primarily with the misdemeanor unit, so I worked with newer attorneys. But I loved that position, and I have just tremendously enjoyed the transition into being a judicial officer. The pros and cons of the job are a bit difficult to describe because I have looked at becoming a judicial officer as a bit of a lifestyle change. Everything changes, at least from what I have experienced so far. And so I will say that I am a natural introvert. So for me, it's a pro that it's a bit of an isolating job. I love having that built-in excuse to turn down the party invitations. But if you're an extrovert, that might be a con for you. And so I think this question, what I would want the takeaway from this question to be is really that as students, find what part of the legal universe you enjoy the most, and then strive to accomplish or to be the best at that. So whether that's big law, nonprofit, government work, being a public defender, being a prosecutor, taking a look at those and then striving to accomplish within that space in the legal field, I think is step one. And at some point along the way, is perhaps around 7 years, you will know whether or not being a judicial officer is right for you. If you decide it is, then you absolutely should apply. And so I think I'll echo the sentiments of many of my colleagues that have been up here that, you know, this has been a tremendous journey. And I think that there are so many pros to it, but ultimately it's a very personal experience and it's a very, it changes your life. And so I would just encourage you to first start by figuring out what part of the legal world you want to practice in. And then in a few years, decide whether or not being a judicial officer is right for you.
Thank you. And Justice Scotland, being a judge means being committed to public service. Is public service a requirement to be appointed or elected to the bench?
Technically, no. Public service, which obviously includes any type of community service that benefits the public, is not a requirement to be a judge. But practically, Adam, I'm going to look at you. Practically, I'm an old first person. From my experience with judicial appointment secretaries and governors over the years, have indicated to me that involvement in some form of community service is a plus, all right? That if a governor had two candidates, one of whom, and they were both equally talented and equally experienced and all of that, it seems to me that a governor would, in a way, it would tilt the scale to appoint a talented attorney who did public service versus an equally talented attorney that had no community service at all. So that's that. And in fact, that's probably the same for somebody who runs for an open seat. I think hopefully I would have confidence in the jurors and the voters to think that someone who did public service would be a better choice than someone who did not do public service. But you know, doing community service is just a positive thing. It's a positive thing for you. It's a positive thing for the community. It opens your eyes to the needs of different people in your community and how you can help those people in your community. And frankly, it can lead to the development of relationships that can help you professionally. So I'm going to borrow the words of Spike Lee, do the right thing and do community service in addition to your practice of law. It pays off for the community and for you personally.
And thank you. And these are questions that, I'm so sorry. Give me 1 second here. Justice Pena, can you discuss the impact of technology and innovation on the judiciary? And do you feel that courts have kept pace with technological advancements? These are tech questions, is what I want to say.
Well, let me start with a disclaimer. I'm not a tech guy. I'm not on top of the latest innovations in technology, even as it pertains to the judiciary. But, well, I can tell you how things were when I first started. When I first became a lawyer back in 1980, really started practicing in 1981, what we used to use was a pen and a yellow legal pad. That was our tools of the trade at the time. At least that's what they were for me. We used to write everything out in terms of whether you were writing motions or briefs or things of that nature. You do your research. You have to go to the library, pick out the books, and start researching manually, and then writing your notes, and then making your outline, and then making your composing your brief or motion, whatever the case was. And then you also had to go through the process of individually going through books. And this might be foreign to all of you. Maybe you've probably never even heard of Shepherd's books. We used to have what were called Shepherd's books so that we could determine whether the case law that we were relying on had either been overruled, modified in some way, become unpublished, or anything that may have caused that case law to no longer be valid or important for the points that were made in it. And so, you'd have to go through the process of, there were like about 4 books. You had to pull each one because they were updated. And so you start with the original, and then you keep going to all different updates. Well, things have changed since that time. And now we're in, I guess, more of a computer world where all of our composition and really most of all of our work is based on our computers, right? And it's developed over time. And I would say that the judiciary, I do believe that we're trying to keep pace with all of that. So the Judicial Council of the courts here in the state of California have what is called a Information Technology Advisory Committee. And this committee is to try to keep up with technical innovations. The mission statement of that committee is, the committee makes recommendations to the council for improving the administration of justice through the use of technology and for fostering cooperative endeavors to resolve common technological issues with other stakeholders in the justice system. So what do I mean by other stakeholders? Stakeholders would be attorneys that use the court system. It also could entail parties who are self-represented. So these days, I think all of the courts, whether they're superior courts or courts of appeal, the Supreme Court, all have online services, I believe. They all have some kind of a website that people can access through their computers now. And we have been, certainly at the 5th District, we, I think, have been upfront in streamlining and getting to the point of being completely electronic. So we now file or have the parties file their briefs, the records all electronically. So, I mean, if you had started when I started, this is mind-boggling in terms of thinking where I started from to where we are now. Again, I'm not a techie, but we also have what's called the Center for Judicial Education and Research. We call it CJER for short. And what that organization does is it gives us judges and justices training, also present seminars, different types of courses that we can take. Among them are courses in technology. I know that within the last 6 months or so, I took a course in artificial intelligence. That's something that's coming up, and maybe it's already here, right? We're trying to learn about that, the good things, perhaps the bad things about it, but mostly it's coming. We need to prepare for it. How do we prepare for it? And I expect that there are going to be many follow-up courses as it does enter into the court system, and we start having to deal with more of it. My, I guess, final impression is that the judiciary is keeping pace and will continue to keep pace with new technology.
And thank you. And Judge Vasquez, how do you balance the demands of judicial duties with personal and professional commitments outside the courtroom?
So when I reviewed this question, I thought back to my swearing-in ceremony where I stated that the only reason I am still standing at the end of every day is because I have surrounded myself with some of the most wonderful people that this world has to offer. So I will tell you that I balance the duties by not doing it alone. I think that we are not meant to do this life alone, that people are important and relationships are important and connections are important. And so in order to make sure that I am able to fulfill all of my professional commitments and my personal commitments, I have a very strong support system. I am not someone that is always comfortable asking for help. I struggle with that particular concept. And so the moment that I released my ego and I started to ask others for help and allowed them to show up for me, and they gave me the opportunity to show up for them, it was life-changing. And so I think that there are ways to balance personal and professional commitments. And the way you do that is by forming connections and relationships with people. I found myself as recently as yesterday trying to figure out a way to balance my personal commitment. My daughter got sick and I needed to figure out a way to get her to the doctor. And I also was in court that day. And so I had a whole army of people showing up and offering to help and making sure that I was able to both take care of my daughter and then take care of my professional responsibilities as a judicial officer. So the way I balance it, again, is by relying on other people, by reminding my people that they matter and that they come first, and so I would just encourage everyone to just step outside of their comfort zone, to form connections. And, just that I found that some of the most unlikely connections have become my most treasured ones. So.
Thank you. And Justice Scotland, for the last question of the day, what are your most significant cases or decisions that you've presided over, and what guided those rulings?
So that's a difficult question for, like I said, an old guy like me who retired from the bench almost 14 years ago after serving over 23 years as a trial judge and then on the Court of Appeal. And thereafter failing retirement, because now I'm practicing law again with the Nielsen Merksummer Law Firm. Out of the thousands of decisions that I made over those years as a trial judge and as a Court of Appeal justice, and of those I can still remember, I'm going to start first with most of my rulings as a family law judge were significant, not in terms of the big picture of the law, but they were very significant to the parties in your court that are going through a very difficult time in their lives. And not only the parties, but the children of the parties. And so there were significant decisions. And so there was a pressure, a thought that you really wanted to get it right. It's so interesting. As a family law judge, you have wide discretion on many things. For example, what's in the best interests of a child, okay? Also, because most of the parties don't have sufficient funds to do adequate discovery, you're not going to have all the facts that you would hope to have to make the best decision you could. And because of the burden of proof, which some family law judges refer to as the, quote, preponderance of the perjury, unquote, because not all of the parties are necessarily being quite honest about things. You hear different points of view from each. That can be difficult. So, but what guided me in those decisions always was following the applicable rule of law and applying it to the facts as you can determine them, and then just making a common sense determination of what is in the best interests of the children primarily and the parties. You just have to do your best with what you have. Among the very memorable decision, probably the most memorable decision I had as a trial judge presiding over criminal law matters, including a number of very significant homicide cases, was granting a new trial to a defendant after a jury found the defendant guilty of first-degree murder. And I respected the jury, but I couldn't in good conscience let that verdict stand because I felt that the evidence was not sufficient for a first-degree murder conviction. All right. And I thought about that because I didn't want to necessarily override a jury. But I made that decision. I made it about a month after the trial ended because it went out to probation, et cetera. And so this was at sentencing. And I made it knowing that a juror had come back and was sitting in the courtroom to watch sentencing. I know he was not very happy, but that's what I felt that I had to do. The most significant cases while I served on the Court of Appeal for over 21 years were government law cases. And most government law cases are very significant in a variety of ways. And what guided my decisions in those cases was my firm belief that judges should never have agendas, that a judge must follow the rule of law even if the judge isn't happy with the result, and that respecting the separation of powers, judges should not second guess the wisdom of legislation. If there's a flaw in the legislative scheme that's not unconstitutional, it's up to the legislature to fix it and not judges. Those were some of the guidelines that I applied. And I want to, before I end, that's the end of my answer, but I just have to say, Judge Rosas, I loved your restaurant food analogy. And would you please print that up for me? May I please have that? That was probably the most brilliant description. And that was wonderful. And can I do one last thing too? Because going back to mentorship, some people ask me, they're doing this particular job. Should I switch and should I go over to do this? Because they think it would give them more prestige or more whatever. And the bottom line is this: to become a judge, there are just so many positions available. There are so many candidates. Don't do something because you think it necessarily is going to help you to become a judge. Do what you love in the law, you enjoy, what makes you feel good. Don't be miserable doing something because you think it's going to benefit you to get a judge. It's just going to make your life miserable and you might not get that judgeship. So that's the end of it. Anyway, sorry, I extended over my time.
And I want everyone to know that there will come a day where you're going to want to, what did that judge say, or what was the advice? This has been filmed on YouTube, and it'll be available on the Historical and Research Society at McGeorge website. So whenever you find yourself maybe 7 years from now or 10 years from now, or you're facing a challenge and you want to remind yourself, what did that judge say? Please go watch that video again. All the advice they gave you here tonight will not be in vain. They will become your survival kit in your legal journey and hopefully in your time and your application as a judge. So with that, our program is concluded for the night. And don't forget to be kind to yourself and each other. Good night.
Thank you, Josue. Great presentation.
What a pleasure to meet you.
A lot of great tacos in the back still. So
Now what you need to do is you need to become a Court of Appeal justice, because then if your kid gets sick, you're only in court a few days out of the month, so you have much more flexibility. Yeah, right. Oh my gosh. Oh, God.
It was so good. Like people were volunteering my calendar,
Nice.
it all worked out at the end of the day. Of course,
So let me use this as an opportunity, because I came to the Fifth Appellate District, talked about it starting at in the court in Fresno. I would love to
I remember.
Yeah, I would love to see, and I know Brad Hill, who's the presiding justice, and I know, and her name escapes me right now, a judge on the Superior Court, and I know a magistrate judge are interested in doing it. Oh, so I hope you We got to get Emily.
Yes. Emily.
Which bus?
I know. Judge Vasquez, I won't get to that one.
G Vasquez. And B Vasquez is hiding. I am hiding.
Go ahead and tap her on the shoulder. I think that's the only way it's gonna happen. One of them went over.